Can a trustee ask a beneficiary to release them from legal liability? And what does it mean to sign a release?
So a lot of times in trust cases, trustees want to be released from legal liability. Obviously, they don't want to be sued in the future, but what exactly does it mean to sign a release, Stuart?
Well, signing a release, sometimes it can be fine, but in most cases it is not, in my opinion. And so the answer to this question really is, it depends. Why is the trustee asking you for a release? Well, it could be that the trustee's done a very good job and just simply wants to button up the trust administration and move on after the trust has been fully administered and the distributions have been made. And it's just a precautionary thing that a lawyer that's representing the trustee is doing. But it could also be that a trustee has done things that are inappropriate investing. There could be losses to the trust assets. And so if you waive liability, you're essentially saying that you're not going to hold them liable in the future for anything they might have done while they were trustee of the trust. It's a pretty big ask. So at a minimum, I would say if you're going to sign a release of liability to a trustee, you've got to have information to be able to base that opinion. You've got to have meaningful information to look at before you sign away that release. And that could be, we'd be open to signing this release, but we want to get documents from you showing what you did during the trust administration, bank statements, financial statements, real estate closing statements, real estate contracts, anything that shows the valuation changes of the trust during the tenure of the trustee. Those are the things you want to analyze. And if the trustee's not willing to give you that information, then I would not waive liability. So you got to be careful with this. You can waive liability if you want to as a beneficiary, but be careful doing it. Make sure you have a good understanding of all the underlying transactions that the trustee did while trustee, and then it might be okay. Otherwise, don't do it.
And what happens if a beneficiary signs a release because that's the only way that they're going to get their distribution, and then they find out that the trustee has done wrong, stole money, something like that? Is there something the beneficiary can do about that?
So there is a safeguard in the probate code that says, look, if a trustee doesn't give you all the meaningful information about a trust before you sign a release, that you're not signing a release as to the information that was withheld from you. But it's an uphill battle. Be careful. Now you're having to go into court and tell the court, I wasn't given information, and they're going to have their story about how they did give you the information, and that's a released piece of liability. So that's why when we sign these releases, we do it very carefully. We want to make sure we have all the information. And if we show the court, hey, we got all the information, court, we signed the release, and the one bad thing they did, they didn't give that to us. That's a meaningful fact that we wanted to know about. That's something we needed to understand before we signed the release. They didn't give it. Probate code kind of gives you an out in that regard.
Right. Great. Thank you.
Albertson Davidson is here to help you fight for your inheritance. Check out aldavlaw.com for our complete library of helpful legal videos and articles from your favorite California trust and will litigation law firm, Albertson Davidson, LLP.